Okay, I mentioned reasonable doubt in a couple of my other videos, but I wasn't very specific about it, and it's a mandatory. Okay, remember, a mandatory. So this is law. Reasonable doubt is a high legal standard in criminal cases requiring prosecutors to prove guilt so thoroughly that a juror has no logical reason to doubt it. Meaning guilt must be established with near certainty, not just probability, protecting the innocent by requiring strong evidence for conviction. It's the cornerstone of justice, often contrasted with civil preponderance of evidence. The phrase also refers to who legal drama, reasonable doubt. No, I don't want to know about that. In law, reasonable doubt definition, a doubt based on reason and common sense arising from fair consideration of evidence or a lack of evidence, not mere speculation. Burden of proof, the highest standard. Burden of proof, the highest standard, meaning jurors must be firmly convinced or have an abiding conviction of guilt. Purpose to reduce wrongful convictions, upholding the principles that it's better for 10 guilty people to go free than one innocent person suffer. And they have people that'll explain it to you. Okay, so, and like I said, don't let it, so there's going to be some people that are egregiously moronic are going to tell you that doesn't mean what you think it means, but hold them to the letter of the law. There are penalties for violating the letter of the law, and in violating the letter of the law, if death is involved, one can receive the death penalty for violating the letter of the law. Penalties are fines, removal from public service, and incarceration. That's also disinformation if they tell you, well, let me tell you what it means to me. No, it says what it says. It is what it is. The letter of the law requires that to be done word for word to the letter. Okay, this is just another legal termination, that I use in my videos. If you look at my videos, you just look at the titles, and those are legal terms. And I just give it a legal term, and in the video is the definition of all those legal terms. And you watch those videos, and you can throw all those legal terms together and make, when you're asserting charges, all you need is the law. You don't need evidence because that's what they keep from you. Okay, in civil cases, that's how I won, on the preponderance or evidence or lack of. No evidence. Just hearsay. Okay, that shouldn't have even been brought to court. They filed voluntary non-suit. They had 1 year to refile. If not, they lost their chance to refile. But still, it was based on a conspiracy against rights under the color of law. Everybody involved in the case, the judge, the lawyers, the judges, the lawyers, they all knew. And when I tried to furnish evidence, they didn't want it. In the civil case, they used the conviction from the criminal case. They waited till that was over before they started filing any serious issues and decided they wanted to go to trial. And they thought it was an automatic win because there was conviction in criminal court. But before I could state my claim on a conspiracy against rights under the color of law, I overzealously told my lawyer. He ran and told a judge and walked the green mile after that. Luckily, I survived. But anyways, I wound up getting out. I got a 15-month sentence, or 3-year sentence. I did 15 months. And I had to defend myself, go pro se in the civil case. So they used the criminal case, thought they had a hands-down win, until I decided to use the evidence from the criminal case, which would negated the civil case. The lawyers didn't want to do that. They talked to the judge. The judge says, I can't use that. I said, but that's what you're using the conviction on the criminal case to say I'm guilty. That's why they're suing me. But you're not going to allow me to use the evidence, the testimony? Well, they didn't use any evidence. I said, yeah, they did, but they didn't allow me, which was discovery. Disclosure is mandatory, and they didn't do that. And even with the civil case, in fairness to the opposing party was supposed to furnish me with any litigation that they were. So any evidence, the trial testimony from criminal case, the hospital reports, the police reports, they were supposed to furnish me with that. They didn't, so I furnished them with it. And they weren't happy. And I issued a copy to the court. And so they didn't want to use anything. So I agreed to go ahead with the proceedings. And the judge said I couldn't have a bench or a jury trial because the attorneys who originally filed for a bench trial, which was ridiculous. And so I agreed, okay, let's proceed. So my opening statement was, Judge, in accordance with, I forgot, but it was about the rule, the Code of Judicial Conduct, the right to be heard. I forgot what canon that is. But I had a copy with me. As soon as I brought up the Code of Judicial Conduct, he got up, and before I could get into the right to be heard, he called for a sidebar. I was excluded. There was numerous attorneys in there. I was the only one that they didn't. Well, you're not an attorney. I said, yeah, but I'm pro se, so I have that right to be there. And no, they decided to have behind closed doors. They called me in there about 2 hours later and filed a voluntary non-suit. And then when I brought up all what I was going to bring up, cite a conspiracy against right under the color of law, the judge's failure to report my attorney for misconduct, the opposing party for misconduct, multiple counts of misconduct, failure to report his misconduct in the codes and the rules of the judge. You're legally obligated to report these buffoons for conspiring to deprive me of my constitutional right to due process in a court of law, fair trial, effective assistance of counsel never happened. And effective assistance counsel is a mandatory of the court, not just my attorney, for everyone to abide by and enforce the rules of professional conduct and the Code of Judicial Conduct. And if anybody is violating them in a court of law, they should not be allowed to remain in that court of law from that moment on. You don't let them carry on and say, well, you could file a complaint with the ARDC, Judicial Inquiry Board, and see what they're going to do. That's what I said I was going to do when they called me into the chambers, and they laughed at me. Said, said a few things, I forgot exactly, but it came down to, it's easier to get a cop to arrest a cop than to get attorneys and lawyers to rat out attorneys and lawyers for violating the oath. This is violating the oath. Remember, I was telling you about the first thing you hold them to is the oath, and then I give you all this stuff that's required by the oath. Okay. So when they violate the oath, there's more than just one set of penalties. Okay, remember, there's not just the oath of office, There's the oath of public service. The oath of public service has a bigger definition to it. So I strongly suggest you look that up first and use that against it. Remember, so that's two sets of oaths. There's the oath of public service. So they're violating that oath, and the oath of office. Whatever office they might hold, as an attorney, a judge, a politician, a cop, the military. Okay. And that's not including deprivation of rights. You know what the penalties are behind that? Each and everybody in that courtroom can be charged with deprivation, or should be charged with deprivation of rights. And that's because nobody reported any of this misconduct. That evolves into a conspiracy against rights under the color of law. But reasonable doubt, people. I've tried to help too many of you in so many cases. It's rare that they're ever proved beyond a reasonable doubt. And any time somebody tells you you don't need to see the hospital reports, the police reports, anything they're going to use against you in a court of law, you need to see it. Because that's what they kept telling me through the criminal process. They wouldn't give it to me. There was arguments. And when I ratted my lawyer out in court, told the state's attorney, it's your job. She says, that's between you and your lawyer. But no, according to the rules of professional conduct and the code of judicial conduct, any violations of the rules of professional conduct between me, my lawyer, you, the judge, every attorney in this courtroom. But she didn't give me a chance to say that. She took off, and the judge didn't want to hear anything unless it was from my lawyer, denying me my right to be heard. And I wanted it, and after she convicted me on hearsay. So since there was no evidence and nothing was proved, all I got left is to take your word against her word, and that's what she judged me on, even though her testimony itself contradicted itself. But they didn't want to use hospital reports, half a dozen stories, different stories she told in there, and it didn't correspond with the testimony she gave about her stay in the hospital or what the injuries she suffered from. They were totally fictitious to what she testified in court were totally fictitious. And that's what I wanted. If I would have had the hospital reports in the criminal case, I would have stated that. But I wasn't allowed that. But I did have them in the civil case, and they didn't want to use that. But was it beyond a reasonable doubt? In the criminal case, no. If I'd have had access to discovery, disclosure is mandatory. I'm getting yelled at. When I wanted hospital reports, what are you, a doctor? When I wanted a court transcripts from the preliminary hearing, what are you, a lawyer? Like this is in a different language. But that's what I'm going to go over with you within the next couple of days. A file I have called Hell's Fury. And those are my receipts. That'll show you, I want to show you what they kept from me and why they were so anxious to to give me, to file a non-suit. I have a copy of that. I'm going to show that to you too, from the court. I walked out so pissed off. They were laughing. I guess so, to make it even seem funnier, they sent me a copy of the non-suit because I left without them giving it to me. So I have that. And you've seen the letter, the response I got from the ARDC, Attorney Registration Disciplinary Commission. They ignored prosecuting these people for violating the rules of professional conduct and the code of judicial conduct. So we aren't going to interfere in your case. I didn't ask them to interfere in their case. Every lawyer that participated in that case, in the criminal case and the civil case, the judges that participated in that case, in the criminal case, in the circuit court as well as the appellate court, and then, it's just so many people were involved. So many people were involved in denying me my constitutional rights. The Bill of Rights, my civil rights, the rule of law. They put themselves above the law and put me below it. This is not how the system works, and that's what I teach you on legal reform. I try to teach you how the system is supposed to work. I give you the oath, hold them to that first, and everything else I put are the legal obligations of all your public servants, and they ain't doing none of that. That's what legal reform is about. Teaching what you need to know to stop them from doing what they're doing to you and getting it on the record. All right, people, nothing but peace and love for you, all right? May your Creator always be with you and rain many blessings. I wish you nothing but a long life and good health. Good night. Nothing but love for you, one and all.